Under section 61, proof of content of the documents. Documentary evidence means all documents produced for the inspection of the court. Documents are of two kinds, public and private. Section 74 gives a list of documents which are regarded as a public document. All other documents are a private document. Production of document in courts is regulated by the Code of Civil Procedure and a Code of Criminal Procedure. In the case of Murarka Properties Private Limited versus Biharilal Murarka, AIR 1978, Supreme Court, page 300, it was held that the content of the document must be proved either by the production of the document, which is called primary evidence, or by copies of oral accounts of the contents, which are called secondary evidence. Where there is documentary evidence, oral evidence is not entitled to any weight. In a case of Puran Bakshi Mishra versus Rajkumari Mishra, AIR 1995, Orissa 284, it was held that where a document was not required to be registered, it was admissible in evidence, even though unregistered. In the case of Krupa Shankar versus Gurudas, AIR 1995, Supreme Court 2152, it was held that an ex parte affidavit without affording an opportunity to the other party to test the veracity of its cross-examination cannot be proof of its content. In the case of D.B. Thakur versus State of Gujarat, 1995, Criminal Law Journal 3751, it was held that where the executant of a document is admitted in its execution, the same could be received in evidence. 62. Primary evidence means in a case of Kamla Rajmanikam versus Susila Thakurdas, AIR 1983, Allahabad, page 19, it was held that this section defines the meaning of primary evidence, which means the document itself produced for the inspection of the court. Where document is executed in several parts, each part is a primary evidence of the document. Where document is executed in counterpart, each counterpart is a primary evidence as against the party executing it. Where number of documents are made by printing, lithography or photography, each is a primary evidence of the content of the rest. Where there are copies of a common original, they are not a primary evidence of the content of the originals. Two wills in identical language were prepared by the process of typing, in which the second copy was obtained by carbon impression. Both were duly executed and attested. Both were held to be original and not one copy of the other. The fact that the testator inserted a remark on one of them as a true copy would not alter their character. In a case of State Bank of Travancore versus Velayuddin Pillai Bhaskaran Nair, AIR 1997, Kerala 32, it was held that sometimes each party to a transaction wishes, for the sake of convenience, to have a complete document in his own possession. To effect this, the document is written out as many times ever as there are parties, and each document is executed. That is, sign or seal, as the case may be, by all parties. any one of them may be produced as a primary evidence of the content of the document. The duplicates of partition deed executed and registered along with it, whereby the properties are created in favor of several persons, are to be treated as originals itself, having the same operation and effect as that of the other. In case of Bhagwaganj versus Kalyanji versus Punjabhai Hajabhai Rathod, AIR 2007, Gujarat 88. It was held that where a document is executed in a counterpart, each counterpart being executed by one or some of the parties, each counterpart is a primary evidence as against the parties executing it, and secondary evidence as against the other parties. A document was executed in two parts. The plaintiff left with the carbon copy of which was executed in the very same process, but was in fact a counterpart of the original. It was held that carbon copy was to be regarded as primary evidence under the section and produced as such. The party against whose interest the document was sought to be produced could challenge its genuineness or disprove the same. In a case of Prithi Chand versus State of Himachal Pradesh, AIR 1989, Supreme Court 702, it was held that where a carbon copy was made by one uniform process of the certificate of a doctor given in performance of professional duty, it was held to be a primary evidence within the meaning of the explanation. In a case of Rajesh Rai versus State of Sikkim, 2002, Criminal Law Journal 1385, it was held that police station diary contained duplicate pages. A carbon copy was prepared by the same process by which the first copy was prepared by the same process by which the first copy was prepared. Each was held to be primary evidence of the content of the rest. Of Nakul Koti versus State, 2010, Criminal Law Journal 4536, it was held that accused was charged for allegedly giving a fake visa after charging money. It was pleaded on behalf of the accused that he is entitled to discharge as a document of visa was photocopy and thus secondary evidence. It was held by the Delhi High Court that in a given case where photocopy is used as a primary offending articles, the same would be primary evidence for the purpose of a trial of the said case. In a case of Rajrani Sehgal versus Purushottam Lal, AIR 1992, Delhi 134, it was held that Section 276 of the Succession Act of 1925 requires that an application for probate or letter of administration should be made with a will annex, since this does not necessarily mean the original will. A copy certified by the sub-registrar was allowed to be annexed. Ramajayam versus Inspector of Police, Chennai, 2016, Criminal Law Journal 1542, Para 8, Madras Division Bench Judgment. It was held that the court has the power to view CCTV footage and video recording, be it primary or legally secondary evidence, in the presence of the accused, for satisfying itself as to whether the individual seen in the footage is the accused in the dock.